Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to Florida. Doesn't have to be ridiculously complicated. I can pretty much summarize it. But here, the Florida's appellate court ruled that when a fire chief, as part of his job responsibilities, reports on matters to the public and issues a public written or oral or both statement on that matter, that you can't be found, you're immune from defamation. Right now, let me be careful. This doesn't mean, and I'll give you the facts really quickly, but this doesn't mean that just because you say something that it's automatically immune, right? If you lie, lying is not going to be in your job description. So here, every attorney knows that truth is the ultimate defense to defamation, right? When you say something and it's true, you can't be sued for defamation. This wasn't the holding of this immunity decision, but you can bet that if it was untrue, the immunity would not have applied because lying is not part of your job description. So here, basically, there was, I'll summarize it because it's horrible.
I'll give you the facts if you want, because
sure.
I'm familiar with what happened here. And we had, it sounds to me like it was a prank gone wrong, but it was also two pranks. On one level, it could be pranks going wrong. On another level, it could be blatant racism. So which of the two, we'll leave it to folks to kind of work their way through. But we're at the city of Miami. We've got I imagine one shift led by one lieutenant decides to pull a prank or harass a lieutenant who's African American on a different shift, and he apparently left some family pictures out, so the firefighters drew some phallic symbols on the pictures. Okay, so that's sort of prank number one. Couple of days later, someone else, and whether it was a noose, whether it was a piece of string with a knot or whatever it was, but there was a piece of twine or whatever that was shaped like a noose that was draped over one of the pictures. So two separate events over 2 different days. And the lieutenant, the African-American lieutenant, now comes back, sees the defamed, the pictures, sees the noose, is offended, contacts the department, complains, and an investigation is launched. And I believe there was somewhere between 11 and 12 members that were involved, some level of involvement with it, 6 of whom were terminated. Okay, at the conclusion of the investigation. The investigation pretty clearly said some of them only drew the phallic symbols. Someone else did the noose. Okay, so what we've got now is the 6 firefighters were terminated, several others were disciplined, there was appeals, there was suits off to the side of that related to this case as well. 3 of the firefighters who were involved in drawing the phallic images, they weren't involved in the noose, but they were involved in the phallic images, filed suit against the fire chief in the city of Miami, claiming that they were defamed because when the chief made public statements about the incident, he didn't make it clear that there were 2 groups here, and they felt that their reputation, their ability to get jobs in the future now were going to be jeopardized because they were being labeled as racist. And they feel like what they did may have been inappropriate, but it wasn't racist. So they sued the chief and the city for defamation.
And look,
all yours now.
Well, no, it was defamatory, right? I think that rises to the level of defamation, but doesn't matter, right? It was true. It may have not been said perfectly, and maybe a private person would have lost if they said that. But here, very simple. They said the fire chief's acting in the scope of his duty when he reports on this, and that's the end of it. He's immune.
Yeah, so the chief statements were made public. One was in writing, one was at a press conference, but they were made publicly. So what could change this? Let's say the chief made the same statements, maybe not in his official capacity, but maybe to someone on the side.
Right.
not as part of his official duties, well, then you have a question of fact whether they were in his official duties, not, and all that. The immunity might not apply. But here, he made the statements in his official capacity, and he has immunity for those statements.
It's really all we need to say.